Constitution framers were very wise people. People who deeply believed in national welfare. They debated for 18 sessions for over little less than 3 years. There was no confrontation. There was no disturbance, no disruption. There was dialogue, debate, discussion and deliberation. Very contentious issues. But they framed one rule. The judges will be appointed under Article 124. And a consultation word was used. Boys and girls, you know the word consultation? Lexicon defines it. Consultation is not concurrence. Consultation is consultation. Article 124 was very specific. And with respect to Article 124, we have a very important discourse by Dr. B.R. Ambedkar. And B.R. Ambedkar, who did a great job in giving us this constitution, I am quoting him. This was with regard to the question of the concurrence of Chief Justice. And Dr. B.R. Ambedkar says, I quote, boys and girls, for your benefit. I quote, I think to allow the Chief Justice practically a veto upon the appointment of a judge is really to transfer the authority to the Chief Justice, which we are not prepared to vest in the President or the government of the day. And Dr. B.R. Ambedkar goes on to say, I quote, I therefore think that is also a dangerous proposition. But in the second judge's case, in 1993, the court interpreted consultation will be read as concurrence. Can it be done? The two words, boys and girls, are different. But the bench did not notice that Indian Constitution uses these words, consultation and concurrence, in the same article, Article 370. With respect to the then state of Jammu and Kashmir. Article 370 has both expressions in the same sub-articles. How can these two words used differently by the Constituent Assembly members in the Constitution can be read differently? It was done. Now, the situation is engaging attention of everyone. And it is our obligation as citizens of this country to think about how things have to evolve. I have no doubt Parliament cannot script a judgment of a court. I have no doubt about it. Parliament can only legislate and hold institutions, including judiciary and executive, accountable. But judgment writing, adjudication, is the sole prerogative of judiciary, in as much legislation is that of the Parliament. But are we not finding this situation getting challenged? I am saying so because very frequently we are finding that executive governance is by judicial orders. When executive, the government is elected by people, the government is accountable to parliament. The government is accountable to the people at election. There is a principle of accountability in operation. In parliament, you can ask questions, critical questions, because the governance is by the executive. But if this executive governance is by judiciary, how do you ask questions? Whom do you hold accountable in election? Time has come when our three institutions, legislature, judiciary and executive, must blossom. And they blossom best, and best for the nation, only when they operate in their own area. Any incursion by one in the domain of the other poses a challenge which is not good. It can upset the apple cart. The relationship between these three must be wholesome, soothing, one of deep understanding, coordination, co-liaising, not to show authority. Historically and also presently in many nations, judges speak through their judgments, and only through their judgments. Those good old days are gone now.
If you like the video, do like, comment, share and subscribe. If you like the video, do like, comment, share and subscribe.